Guys, I want to welcome you to another episode of the Advisory Board podcast, where we bring in experts from the franchise community and have them share their knowledge, wisdom, so you can build a better franchise brand, franchise brokerage, whatever you're working on. And I've got with me a friend of mine, and also just a brilliant guy that if you don't know, I wonder what rock you've been living under in this industry. I've got Lane Fisher with me, co-founder, senior partner at Fisher Zucker law firm. And I really appreciate you making time, Lane. I know you're crazy busy. End of year is always fun with things that are happening. So I appreciate you joining us.
Thanks, Dave. Thanks for having me.
Yeah, I'm going to brag on you for a second, though. So people that don't know Lane, I want to share a couple of things with you may not know. So he has been in private practice law since '89, right? He started Fisher Zucker in '95. He represents over 150 brands. Lane's one of those guys. If you don't know him, he just knows what's going on in the industry, and he's known what's going on in the industry since I was in second grade or something, right? So it's just, I'm not trying to poke fun at age, but Lane just knows stuff, guys. So I thought it'd be great to have him come on. We're going to talk today about what's changing in the regulatory and compliance part of franchising that's going to affect brokers. And before we dive into that, I got to tell you a few more fun things about Lane that you may not know. So one, this is new. So you guys, if you haven't been to Lane's one of the masterminds behind Unconference, and especially the franchise springboard conference, young conference. And they started building these conferences because they saw a need to develop curriculum that people could come and consume and develop younger and more emerging brands. And I'll just tell you guys, shameless plug here. ClientTether goes every year to Springboard. It's one of the best industry events that we've ever been to. There's a reason why it's ranked number 2 only behind the IFA conference, right? It's you guys have done a great job with that event, and they're so focused on quality content. If you haven't been, you should check it out. Even if you're a mid-range growing brand, you don't have to be an emerging brand to show up to that conference. You'll get a lot of value. Like the AI session that somebody gave this last conference, a couple of sessions, people were they were talking about it all night. Out at the bar, they're still talking about content from the conference. That's not normal. So just want to take, hats off to you, Lane, and the team for putting some fun stuff together. That's also super valuable to the community, as well as your franchise sales compliance training program that you guys are launching. In fact, let me stop there for a minute, Lane. Can you tell us a little bit more about that? Tell us just a little bit more about Lane, who's Lane Fisher and Fisher Zucker, and also some of these cool things that you've been working on, like that franchise sales compliance training. I'd love to hear a little bit more about that.
Sure, I'll give you a little history lesson. So we started, and I have to acknowledge my co-host Brad Fishman, because he and I sort of came up with these ideas together. Our first event that we ever did was a franchise unconference, a ski event that had less of the formal educational things that we were all accustomed to, but seemed to attract a very specific demographic of folks who were really interested in skiing, which we also learned does not necessarily mean they're very good at skiing. So there is no correlation between the quality of franchisor and the quality of skiing. So they were actually quite reachable on the slopes where that event ends up at about 10:30 in the morning. So we got lucky there, and we had a great following, and people came back every year, and there was a lot of pressure on us to actually do something that was a little bit more substantive, that contained more educational value, and had more training for folks who are at the beginning stages of franchising. Right. And COVID sort of took that definition and made it emerging or re-emerging, which was a net that sort of caught everybody at the end of COVID. Everybody was trying to figure out what the new them was going to be like. So, but this net of emerging and re-emerging really got us a great cross section of brand new people who didn't know anything, and then people who were a lot, and way ahead of them in the food chain in terms of attendees. And then equally as important, brought out this, we always laugh about it and whatever moniker it goes by, but the franchise family is the biggest family tree in the history of the world, I think. And people are always willing and game to come to an event to try to help someone avoid some of the pitfalls that plague a new franchisor. Rocco Fiorentino, I don't know if you know him, says, you can't physically live long enough to make every mistake on your own, that you're forced to learn from the mistakes of others. But franchising really harnesses that. And I've heard a million people, and your program can either be always do this or never do this, right? I mean, it's some of the, the admonishments come from just the experience that people had. And it was really great. So we had no shortage of folks who were willing to share what they knew. We created our Springboard event really as a thing. We weren't sure how much traction we would get or how how we would supervise or manage the quality of the programming, because I know you know me, so you know I'm very parochial on preparation and getting the right person to present on the right topic who actually has made inroads and strides, and also identifying young, millennial plus, millennial minus people in terms of age that have made these inroads. The beauty of the digital marketing world is that the world is inverted, right? When I grew up, you found the person with the grayest hair who obviously knew the most, and they would try to tell you something, and then you'd know some of what they know. But when the world inverted and you couldn't be 60 and talking about social media and having any credibility, it sort of brought the focus on these young folks. And we look for them, right? We look for people who are the new up and comers, people who are obviously making great strides in these particular topics. And that motivated us to form a whole new event, our Young Conference, which is run by my partners, Zach and Ryan Hicks and Zach Fishman, who have done an amazing job sort of focusing. The content is pretty much is somewhat the same, topically these things are, it's development or not development, but I think the voices that it's heard through, and whether people feel there's a degree of kinship between the person presenting and themselves, or where they see any alignment, is obviously really important, and very important to young people, and very important to the ecosystem of Springboard, to try to identify who the new smart folks were, and then try to bring them up through our other programming and share it with more people. Because obviously Springboard, I mean, we sell Springboard out every year. I think we had close to 800 registrations last year. That's a ton. So that's where we try to socialize our discoveries along the way. But I'm happy to share with you some new dates on our event coming up. And that's the next event is the Unconference in Park City. It will likely be from March 12th to 14th at the usual place in Park City, which is the new park. There's a new opportunity that has come up that we're evaluating at the moment, but people seem to like the economy and the local opportunities to go to these other venues that you can walk to, which are very convenient from the primary location. So it will likely be there. Young Conference will be in Scottsdale from May 12th to 14th. So one's March 12th to 14th, one's May 12th to 14th.
That's nice.
And then Springboard is actually going to be a month later. It's going to be in October this year, from October 15th to 17th. It will be in Philadelphia. There was some thought about moving it, and there may be thoughts about moving it in coming years, because the venues just can't hold us comfortably. And so, you never like to have something that's too baggy. The room's too baggy for the people that are in it, but you also don't like to have people stepping on each other's hands when they're trying to get out. And we do sometimes a better job predicting that than other times. I mean, at our last one, we had Bob Rosenberg, who ran Dunkin' Donuts for 40 years as a private and a family-run company. He's the best example of where you can take an emerging franchisor if you stick with it. For the 30 or 40 or 50 or 75 years that it's now been. But we always like to identify folks who show that it could potentially be worth the effort.
Oh, yeah.
And all Jersey Mike's yesterday transaction for $8 billion. I mean, that's another great example of sort of where these things go. It suggests to me that maybe Rourke bought Subway wholesale, given that Subway had 45,000 units, and there's far less. There's more run space, I think, in the Jersey Mike's world. But there's some really great success stories. The market, after COVID, the market got very liquid, and many of us know many folks who have transacted already, and things we would have told them probably needed to bake a whole lot longer than it was baked. But there's still a lot of activity, even among smaller and smaller franchisors who are becoming part of platform companies and silos where their administrative functions are administered under one roof, but maybe for 5 different brands, either restaurant brands or home service brands, probably more prolifically. But that's that. So those are our new dates. All of our information is on franchisors.com. Franchisors.com will now be the single site that you'll go to register for any of our events. As you know, our event program remembers you, so it's not like you got to start like a freshly shaken Etch-a-Sketch and identify all of your information. It will bring up what you had before, and it will populate it, and it will remember you. And I think we're the only ones who use it. It's proprietary. It drives our events and I think alleviates the need for carrying a separate schedule or doing whatever the paper that people carry when they walk around events like that. But no, so that's that. I did want to I'll circle back also and say that at this Springboard, you saw that based on the exact topic today, this future regulations and this regulator interest in franchise brokerage and sale, and I'll talk about why in a minute, but we incorporated and identified certain sessions during Springboard as for credit, but that was a very loosely used word. It's only really credit with us and yourself as a human being. We think that a best practice for folks who are in the franchise development world is to understand what's going on in the world of franchise sales compliance, what the registration states are doing individually, what they're doing collectively through NASAA, the North American Securities Administration Association, that we'll talk about shortly. And so we gave folks an opportunity to flag when they're attending one of these 3 programs that we identified for credit. And we promised to keep records of their attendance and be able to attest to their adoption of the best practice and then coming to some training programs. When you, getting on topic now, when you read the legislative history in California, it says that brokers are untrained and unscrupulous. And whenever I'm in a group of brokers, I ask the untrained and unscrupulous ones to raise their hand so I can ask them to leave the room. But they're, I don't think they're already. I mean, I'm not going to say that they're not. The community that rides with us and that part of the franchise family are not unscrupulous and are not uneducated. But it would be great if they made training and some franchise sales compliance training as an annual. So that if, God forbid, they ever end up in a lawsuit or in front of a fact finder and they get asked the question that invariably gets asked, which is how much training, when was the last time you had training? And I can tell you as a lawyer and a litigator, that answer is always, I tried to tell you that earlier, like they don't know or remember versus saying, listen, it's a very important part. We do it every year and everybody who joins our organization does it. And we bring lawyers in from the outside to do it for us locally. That some people will say, well, we have a great training program. And so ours is great. So we're just going to rely on ours. And I hope that brokers have great training programs and the franchisors have great training programs. Right. But the legislators are acting, and they're acting because people are complaining. It must not be foolproof, right? Because there are either unscrupulous people on the outside doing bad things. But in any event, we have identified curriculum. That curriculum is a franchise sales and compliance sort of regular old training session, and then stuff as it relates to franchise development. And then we're trying to deal with the bigger issues that are, what are the ethical issues at stake? We're trying to deal with responsible franchising without calling it that, because that term got sort of adopted by everybody. Even people use that term while they're doing irresponsible things. And so I think it means different things to different people. IFA has tried to put a definition behind it, which I think is probably the right definition. But it's the term has been used and abused, and I'm trying to make sure that at least our audience gets some training in what the most influential, iconic people in franchising think are the ethical issues at stake in responsible franchising, whether they relate to the size of the person, the franchisee who's taking the opportunity, who, if it's Greg Flynn, the largest franchisee in the universe, there's nothing you can sell him that would surprise me as like irresponsible as it relates to Greg Flynn. But, if you were a person that had no business experience buying 100-pack of something or buying, you can see some of the magnitude of deals don't match up with the qualifications in the other. And similarly, some of the franchisors who don't have a lot of infrastructure or experience probably shouldn't be selling 100 packs, right? I mean, or some other thing where, so there's some experiential requirement, I think, that you have to look at and decide what elements are important in discharging it. So I didn't mean to go off on a giant tangent with that, but that's what this whole session and what you've convened this call for was why we changed up Springboard so that people immediately could automatically, because otherwise we were waiting another year for Springboard. We thought if for the initial people that cared about compliance, we could demonstrate their compliance earlier. IFA, I'm sure, is going to come up with a much more comprehensive training program with 1 million modules, and I encourage people to take those. I think some of those might be available now, and then they also ultimately be folded in when the state regulatory requirements include or incorporate an education requirement or a certification requirement of some sort. But as I said, I think there's not a point where you're like, oh, I got too much training. I mean, it may be start to pile on itself, but I mean, like, you're never going to be faulted for having too much training in responsible franchising or regulatory compliance in a world that is regulated as much as franchising.
Yeah. What I love about Lane, what I love about what you're doing there, yeah, you've been in this long enough. We've established that you can kind of see the writing on the wall a little bit. At least I haven't been in it near as long as you have, but I can see when I start looking at what's happening that yet we're playing chess here, not checkers. Like, you have to think 2 miles down the road and say, well, if people are starting to say these are uneducated, unscrupulous people, then we need to validate the opposite, so that when some of the ambulance chasers show up, then we take those chips off the table. Like, nope, I am educated. Nope, I am not unscrupulous. Like, we have to start thinking ahead of the game so we can protect the business model that fuels all of our lives and so much of the economy. I appreciate you guys thinking ahead, and I know, like you, IFAs, thinking about it, working on things, and I'm sure others are too. But I'm grateful that you guys are seeing the iceberg a little bit and saying, hey, let's just work around it. Let's turn now and skip this mess.
And we're trying to, like, draw the line between, like, dumping too much information where people stop listening one sentence in because you're really granular, to pointing out, like, hey, McFly issues that you'll want to at least be paying attention to going forward. And by sort of issue bombing people with those things, like, I think we are getting people coming around. I get a lot of people that, and I try to write on it as soon as I throw it out there as an issue bomb too, so that if there is at least something when you go Google it, to go look on franchisors.com that will tell you what we know. I mean, a lot of what we know, honestly, we learned from IFA and from Sarah Davies, who's the general counsel and who is the person on this broker issue, who has had her finger on the pulse, who has worked tirelessly to try to make sure California is the way California came out versus so there's 2 laws we're talking about. California passed a new broker law. So I'm going to talk about that briefly.
Yeah, please do.
NASAA, the Securities Administrator Association, that's the group of folks that run all the registration states. So they pass recommendations that they want the registration states to each adopt. Sometimes it's really easy to adopt the recommendations. Sometimes you got to go through a whole rulemaking process. That's a state-specific item on how they pass laws and regulations that is beyond the scope of this. But there are 2 things moving in parallel, attempting to regulate the same thing. And I find it so funny, but the NASAA regulation is actually worse, more onerous than the California one, which people are like, what? The California was better on something? Well, here's what happened. Let me give you a little history. So IFA has historically been against any addition to regulation, on the theory that we're already overregulated and franchising is regulated, and so it typically opposes additional regulations. But there's a big push to be for something. You just can't be against everything, or you don't have a seat at the table.
Yeah.
Right. So that and I think that there's a point at which that the battle is. What did they say during the election? That you don't have to be a weatherman to see which way the wind is blowing. That what is happening ultimately. I'm losing my train of thought. I know you can edit this, so I'm not worried. What did I say right before that?
We were talking about how, like, Sarah Davies, IFA, they can't be against everything. So as this California regulation was coming up.
Yeah. So and I think when the writing's on the wall that you're going to lose, like, the best thing for you to do is fold yourself in to be part of the solution. And I think IFA did an amazing job, because they're not huge fans of regulation, but I think they knew that a seat at the table was much more valuable than being, a pushpin of an opposer on the side. You saw and continue to see that they are incredibly active in trying to get folks to file comments in the comment periods for any one of these things, and folks who have an interest or have an opinion one way or another, or even if they don't have an opinion but have an ability to help the overall climate, to write in and to respond to those things. And they, I think, have done a great job in sort of rallying support for, I think, for the principal things people care about. So, but I also think being part of the solution and not part, just identifying everything as a problem is really important. So, and there are certain changes to this rule from the way it was proposed in California that you see have IFA's DNA all over it. And I'll just talk in broad strokes, like the definition of who's a franchise broker and who's covered, that you actually call them franchise brokers. Like the IFA was in that because there's some concern about the breadth being anyone. Like the rule itself says, it's any person who directly or indirectly, and that's the language that gives people agita, engages in the business of the offer or sale of a franchise and receives or is promised a fee, commission, or other form of consideration from a franchisor, sub-franchisor, franchisee, or affiliate, sub-franchisor, or franchisee, including people like franchise brokers, broker networks, broker organizations, and FSOs. So that's what the definition is. Now, it was much broader, and it just said anyone who was directly or indirectly, which could include lawyers, it could include anybody in the lead gen space.
Yeah, lead gen, exactly. Yeah, that'd be a nightmare. Can you imagine that?
It could be you, Dave. If it's your CRM sends a document or an agreement or a DocuSign, like it, and I don't think it was intended to cover those things. So that was the first issue, was trying to narrow the scope of who it applied to. And then the second thing is, and most importantly, is who's liable. And that's the principal difference between the proposed NASAA law and the California rule change, is that California does not look to make franchisors jointly and severally liable for this, for some failure to comply, unless they knew about it.
Yeah.
Right. So if you didn't know about it, but somebody didn't file, the law itself requires a disclosure document along with a registration. So you got to file. A registration occurs with the state online. It's accepted upon filing, and then this disclosure document, which in some way looks a little like an FDD, needs to be delivered to the prospect, but not 14 days before you sell like an FDD. The moment you're talking about it. So they really want it to be the first thing given to people. But that to me is like, so you can breach this by failing to register, failing to pay, failing to renew, failing to give the disclosure document on time. And those are all like technical violations versus you didn't talk about your litigation and bankruptcy history. You said you had none and you have lots of it, right? So that's a substantive disclosure. And so you have to distinguish between all of those things and what the appropriate remedy is. If you didn't pay a $60 registration fee, like Lane Fisher feels like you should be able to pay the $60 fee, either the organization itself, or if you're part of a broker group or not, to cure it. But I don't know what would happen if you failed to disclose your litigation and bankruptcy history, or never gave the people the document till 1 minute before you were taking their closing, on their stuff. The good thing about this is that the implementation date for this looks like mid 2026. They apparently put it to Sarah need all of 2025 to build the online portal.
Good.
So it isn't like something bad's going to happen this second. You're like, oh my God, you don't have to do anything right now. You just be aware that this is percolating. And if you have some interest in this law or have some problem with the definition in it, you should be active about it rather than hoping somebody else in the, brokers are notoriously famous for letting franchisors deal with the issues and problems. And for, I guess, the life of franchising, all the disclosures have been on the franchisor's back, even as they relate to brokers. But now this is squarely on the brokers as a broker compliance portion. And then it's, could be many brokers, right? It could be an FSO and sales organizations and consulting groups and all in the same transaction.
Man.
So like you need to, and I'm not quite sure, I don't want to there is no last word on this. The law's obviously it's been signed into law, but some of these things are vague and it's not clear. I can tell you what I heard about some of these problematic disclosures. So let me go through through some of these disclosures, because I'm trying to do the high level things and not talk about the other things. And I'm reading right out of the law, but you're supposed to, there's like going to be a page like the front page on the FDD that has pre-printed stuff that talks about what a FSO is, what a franchisor broker is, and what kind of services they perform. I don't think that will be something you'll be modifying. I think that's something you're just going to be attaching. It'll talk about, let's see, the types of sellers, third-party franchise sellers' role in the process, services they may provide, but more things that apply to everybody generally in that field. Sample questions to ask. And then more specifically as to the franchise broker, and they changed the name in this last iteration from third-party franchise seller to franchise broker, I think to match up with what those laws look like in Washington and New York today. So Um, all the registration states require some disclosure of brokers. Only Washington and New York require separate filing and registration, and this is kind of like what they have, but with
Okay.
more owner obligations. So then the broker, him or herself, has to identify their legal name, their trade name, the year they were formed, the principal place of business, who the owners, officers, and directors are, with their contact information, whether they are affiliated with a broker network or franchise sales organization.
Mhm.
So those are more like identifying characteristics. I don't see those as being like extraordinarily controversial.
Yeah.
And then you have to talk about the franchise sell brokers' professional experience during the last 5 years, including not limited to employers, principal positions, each position's location, and the month of year, start and end date. So they're trying to get to an experiential disclosure for the broker, his or herself. And then where it sort of starts to fall way off from the FDD is in terms of litigation. So the main thing I'm told was that they wanted people to be aware of the litigation.
Yeah.
And I always thought that it was more attempting to try to bring some transparency into who gets paid out of the closing proceeds, if you will,
Yeah.
which is, I think, also important. I'll talk about that in a minute.
Yeah.
But they say it's mostly the litigation and bankruptcy disclosures as they come in. But here in the broker disclosure world, they would be administrative, civil, or criminal actions. So I don't know if a mediation's one of those or not. Mediation is typically not disclosed in an FDD, right? Or the resolution. And then alleging that the broker or an owner, officer, or director of the broker violated any franchise, any antitrust or securities law, or committed fraud, unfair, or deceptive practices, or similar violations, whether pending or resolved within the last 5 years. So pending or resolved are ones that are obviously threatened or taken, ultimately tried. They're allegations, right? So they're going to pick up all of these ones that would allege anything like this. But this is the principal uh, litigation and bankruptcy disclosure. Some people are arguing about the 5 years. Some people are arguing about whether it applies to it, like, does it apply to you, your broker, organization? How do you, and what's the breadth of disclosure? And I certainly don't know that yet.
Mhm.
And I don't think anyone knows yet. I think we're going to hear more about that.
Yeah.
And then let me just keep going here. So you have to talk about the industries of the brands that the broker represents and how many brands within each industry the broker represents. So that's a disclosure that's not obviously in an FTD.
Right.
A description of the services performed by the broker. In other words, if you're just doing sales or if you're doing site selection or financing or any of those, I know some brokers have more services that they offer. You have to disclose that. And then here's the tricky one, and I'm not, well, it's how the third party broker is compensated, including but limited to how the amount of any consideration they receive is calculated. All right. So what I've heard about this is instead of it being like a colon and then like blank lines that you like fill in, I'm told that it's going to be a drop down box. And so it'll say, I get a portion of royalties. And then you do the drop down box and it'll say 1 to 2%, 2 to 3%. It'll be some thing that you choose from a list of options. It'll certainly be, if you get a portion of the initial fee, it will talk about a percentage of the initial fee that you get. Typically, it's not clear to me whether it looks like it applies to all of the deals you did last year. And they were worried that would apply like a real-time disclosure, like from today backwards.
Mhm.
And much more specifically, what I made out of your transaction that you're sitting in front of me signing, right? So people don't think that. That was sort of like that would be the worst of all worlds, that you had to talk about who's actually getting the commission or how it's split at that level. But how it's compensated. I get a portion of royalties, I get a portion of initial fees, and then people have said to me, Elaine, what if you get, I don't know, an option on stock if you sell a bunch of them or any of these other things? And I don't know whether those will be write-ins or those will be included in some other drop down, or whether you'll just say check and I receive other stuff. I don't know that, but it sounds like it's going to be more simple than just answering these, I don't know if there's 11, 12 points of information where however you might free associate and write them versus you having a standardized way of reporting them.
But Lane, let's pause there for a second, because this was an area that got everybody's knickers in a twist, right? When we first heard about it. But initially the concern everybody had was, well, I don't necessarily want to disclose the array of rates that I'm going to get paid. because it might expose that I'm biased toward the brand that's going to pay me the higher commission versus the brand that might be the better fit. It sounds like maybe this is a swing and a miss here, but that was what I thought the intention was originally, like when they first started making noise about this. But it sounds like it's more, I'm just going to talk about how I'm compensated in general rather than the variability of the rates across the brands.
That's where it ended up.
Wow.
I think there are people that wanted it to be more specific, and who knows how the NASA thing, I'll talk about that in a minute, will come out. But so far,
Mhm.
it looks like this is more broadly over the 12 months ending December 31st. What did you,
Mhm.
how were you compensated? So I guess you could say I received royalties between or a percent of initial fee, 10 to 30%, something that would have a big range and not be particularly telling of anything, and certainly not indicative of what happened in this transaction. I
Yeah.
don't know that. I actually kind of had my eyes on that too in terms of where it was going to go. I didn't know. And but again, if they're more concerned with undisclosed litigation and things that have, people took to that level of dispute resolution, then this seems sensible.
Interesting.
And then there was just they changed this last one, so I'm going to read it to you a little bit differently. But it's the brands for whom the broker sold anywhere in the US in the past calendar year and the total units sold for each brand. They originally wanted a listing of every franchisee and whether it was sold by you or the network, and it got like a whole nother franchisee listing.
Mhm.
It doesn't seem like it's that. I think it's a list of brands. And again, more disclosures concluding at the end of the prior year.
Wow.
I
Okay.
don't know whether you'll have till April 30th to update this. It sort of has a material change thing here. It says like immediately. So that doesn't sound like on my next annual update, people were complaining about that going into it. I don't know how that will ultimately shake out. And
Mhm.
again, whoever's listening to this and trying to make decisions based on it, since it won't be this moment, I mean, I think that you should be well advised to check in with Sarah Davies or other people that can tell you like at that moment what of these things have been resolved. And if you follow franchisors.com or subscribe to the newsletter, we'll try to write on it right away, and you'll at least get what we share with clients.
Yeah. Love that.
So that's that. It does have an implementation date of July 1, 2026.
Mhm.
So you could have retired by then. You could have, whatever it is that it is. So it's not necessarily this immediate. There'll have to be I think they're developing the process now and the methodology for registering, and I think they'll still answer some of these questions. So that's California, and that's really all I know. And I spoke to Sarah yesterday, and I got like a little bit more info.
Love
The
that.
NASA one is worse in some ways. The NASA one has an educational requirement.
Mhm.
It has vicarious liability of the franchisor for acts of the brokers. Now, I don't know if that's how it will ultimately get passed. In fact, they've taken comments on it more recently.
Mhm.
And I'm told that the extent of the changes are such that it will re-trigger another comment period. So what will happen is they'll tell you what was different between the first iteration and this iteration, and hopefully they will have taken out franchisor vicarious liability, and they would have taken out some of these other more problematic things that I'll go over in a minute that people are complaining about. But we don't know. And again, they'll they best advice is that they could come up with something after a notice period by mid next year. That's mid 25.
Mhm.
And then they could say NASA thinks that they could pass something, but they're not rule makers. They're just securities administrators, but they can recommend something, and then the individual members, the member states, the registration states would run it up the flagpole in their respective states.
Mhm.
The NASAA guidelines, and I think it's even discussed with California, talk about other states adopting them. They're not registration states. It opens that door. It thinks that this registration of brokers is like important and should be effectuated everywhere. I have no idea whether other states will pick it up. I suspect NASA will come up with something. I don't know whether the states will adopt it identically as NASA proposes it or not. There have been a couple of historic things that don't matter for this podcast, but I think make that issue unsettled.
Yeah.
They will have a similar disclosure document. They talk about, similar kinds of information. There's no reason to think, there'll be an education requirement, so that's why we're doing it, and I'm sure IFA will be doing it.
Yeah.
But again, it's the definition of franchise broker. It uses this directly or indirectly. And in the California one, they came out with a group of people who it definitely does not include employees, for example, of franchisors. Still not clear. That doesn't include lawyers who send documentation or CRM companies who send extra copies of stuff, right?
So we hope we get written out of that. Holy cow.
Right, exactly. It excludes franchisees, for example, as definition of franchise brokers, as long as they don't get more than $1,000. $1,000 is a relatively low threshold. I mean, people pay much more than that in commissions, and often have VIG or spiffs for franchisees that are higher than 1,000. A franchisee should not garner half of its income from the making of referral fees, but it should. And a lot of people should be paid. They're not one person who sees everybody and has a cottage industry of recommending people. But that's a thing that needs to be refined. Certainly, the franchisor liability piece is going to be the subject of a lot of pause and consternation. If this creates another pocket of contingent liability where franchisors are not responsible for the compliance, only for the breach of it, especially if they didn't know. If they knew, if you know somebody has 22 lawsuits in California and you know that they're not disclosing it, I think you're going to be jackpotted, because I think you're either a co-conspirator or complicit in the misrepresentation or something.
Right.
And whether broker networks are vicariously liable for what a broker, I mean, it could put a broker network out of business, right? One person, if somebody did misrepresent their litigation and it was not a $60 fee, but a rescission claim, is it against you or the broker? And how does the broker take the franchise back? Broker isn't in a position to award rescission because it didn't grant the franchise to begin with, right? So there's issues about damages that, I mean, as a lawyer, I haven't figured out yet. I think they're boring for non-lawyers to think about. And then I think that there's, a 10-year reporting time frame in that NASAA thing so those were 5 things we chose as a law firm to write over in the comment period and identify things that we thought created ambiguities for the franchisor clients and or broker clients and or where they're somehow collaged together and are liable for each other's acts. So lots going on. Oh, so the broker thing, I think I said to you, they thought that NASAA could do something by mid-year and then could potentially pass something by the end of 25. I don't know. That would put that in front of California, and California sort of is moving faster, but California's, has economic challenges in terms of, has no budget. Yeah. So it may take longer to go create a new filing system and a new way to record and report these things. They did just this week drop out of, there's a common place where 6 states reported all of their registration activity, which was looking like a place that they all might be, but California just dropped. So they're now back on their website that the California regulators administer, but it needs apparently a year of upgrades. So that's it. I mean, if you're a broker with a lot of litigation and bankruptcy history, I think the days of you being incognito are done. I think that I don't know how this compensation thing's going to come out. Every time we make a big deal out of all this stuff, there doesn't. I don't know if the needle moves a lot afterwards. People are never going to buy a franchise if they know you got a big commission on it. I think they try to figure out what is a commission, but it does appall people to find out that brokers received such a large component of the initial fee, and it especially surprises them when the franchisor is not in a position to reimburse it or do any kind of refund because the money's all been paid and done. Franchisors will have to keep an eye on this. I doubt they'll do it for brokers because I don't think they want the liability for it. I think they want to keep church and state separate. And I think that could be a cottage industry of lawyers who come up that, I don't know how complicated it'll be. I suspect most people won't have such activity. But that's that. So it may mean that so it's if you're a broker, it's not just brokers from California. You can't sell a deal in California without being there or where the territory includes California. So that'll have some people saying, for maybe this and lots of reasons, I'm going to pass or wait on California. I always think it's funny that with California's minimum wage, people would put that in the first wave of units that are trying to demonstrate how well the concept works when you're going to have a wage factor that's twice Pennsylvania's. I mean, but I think if that's where you're going to operate, and certainly when you do get there, people will have to factor in the higher labor costs and whatnot. But this just is another reason in the long list of reasons that California is more problematic. I think they're doing what they think is the right thing. They're doing it in an attempt to increase transparency and to provide more information and to protect. Look, they're a consumer protection agency.
Right.
They're not there
Yeah.
for you. They're there for
Oh,
them, and they have a lot more authority to issue stop orders. It doesn't look like they're going to approve it or review it, though, Dave. I
mhm.
think you are filed when you file it, and then you just have this delivery requirement on day one, which is unusual. But I don't think there's anybody going to call and say, "Hey, I don't like what you did here in Section 7, and I don't like how you described it." But and it's not clear whether the things that are driven by drop down menus will have a or type a really long description of whatever you do here. We just don't know that yet.
Yeah.
But no, great thing to keep an eye on. I appreciate your bringing attention to your folks around it, this issue, and I hope that you encourage your folks to come to our training and IFA's training, and that
Mm.
we build education into the best practices for bringing folks on that are going to be doing it. I was going to say just as anecdotally, like I don't know how many you receive.
Mhm.
10 million solicitations, many through LinkedIn, but just because I'm
Yeah.
advertising in my bio, so it
Right.
must come up when you search the word franchise. But I mean, there's certainly nobody who say it really means that they think I will be a good candidate for a franchise. It's just that I have franchise in my bio somewhere. So it
Right.
is the level of like blanket solicitation, or like spamming is not, it has a legal consequence, but this
Yeah.
notion of this like huge outreach without any particular pointing um, is imprecise, if nothing else. And then,
Yeah.
the level and extent to which people use their item 19 or butcher their item 19 on social media or say it or do it. Like, come on, folks, you got to read what you put in there. You can't say any more than what you put in there.
Oh, yeah.
It shocks people when I call them and say, listen, I saw your post on, because I'm the police on that, right? I go through and I'm like, this is definitely not something I would do or do. And I try to, give people by way of example, but people should be intelligent about how they approach promotion and lead gen.
Yeah.
Uh,
Yeah, they have to be. I'm the same. I get nonstop invites to buy franchises, and it's funny because I'm like, oh, well, actually, I appreciate you reaching out. I can see you're a broker. Which network are you with? And then what software are you using right now? Like I've actually had people buy software from me who are just auto pitching me with some tool on LinkedIn. But it's I in a nutshell, like this whole thing, like regulating a little bit more on the broker community. Like I think it's not such a bad thing that somebody's thinking in these terms, because it's a little bit of the Wild West, like in some networks are way better than others actually at like at educating and trying to standardize approach and giving them tools and resources so they can be more educated and high quality brokers. And some are just like willy-nilly, like, hey, give me some money and go sell, and good luck out there. And I think generally speaking, most people aren't unscrupulous. I know hundreds of brokers, so do I. Like they're pretty good people, and they know what they're doing, and they also are really picky about who they'll work with. So I think it's the young ones that need a little bit more education, really, where the mistakes happen the most. And I think it's more done out of ignorance than ill intent. That's my personal opinion, but it doesn't matter. Now we've got some regulatory things happening, and I hear the same things you do, that most people are like, I'm not even going to touch California. I don't want to touch it. I don't want to open units there. I don't want to sell deals there. I'm not going to register there. So I think just there are also 49 other states. So that's what I keep hearing people say. So I'm just not going to worry about California until I sell out everything else. So
I think
appreciate
that's good. I mean, and I guess finally, Dave, I thank you for your sponsorship of our events, because I think that we put on a hell of a show. I hope you agree, which we could never do without the support of the sponsors. And we vet and curate the sponsors. You don't just click a link and sign up to sponsor our thing. People wish it was that way. They call me and try to find out where that link is, but you really have to be invited. And they're really people that we know and have some dealings with and know other successful outcomes with other franchisors. And so I appreciate you being part of that community. I appreciate you spreading the word. And I appreciate you being there every time I ask you to come do our next thing that we try to throw out to try to get to another sort of section of that emerging audience that
it.
we think is unique. But thank you so much for the opportunity to spend the afternoon with you. Thank you.
Yeah, well, you're a good man. Thanks for your time today. I appreciate all the wisdom and kind of giving us not a bullet point, but like a pretty in-depth overview of what's happening. So I just want to echo what you shared. this is not an issue where we can all just pass on and let somebody else take care of it. We've got to find that when NASAA has its comment period, we all got to make comments. We got to talk to our legislature. I'm actually late to a meeting with my legislature right now. I need to drop off and get into a meeting because it's important that we're involved in these discussions. Lane, thanks so much. Got to let you go today, but I appreciate all the wisdom that you shared and all the good. You and your comrades, Brad and your legal team and Sarah Davies, got to give her a shout out. You guys are doing great things for this community, and I just want to make sure that you get some love for that. So I appreciate it. Thank you.
Thanks for having me, bud.
Yeah.
Folks.